advertisement, the exam on the basis of the revisions is valid and can be held, it will not amount to changing the rules of the game.
The question to that effect is, what was the change? Relevance of the change?
There were inclusions that were made here.
What inclusion?
My lords, inclusion of certain other category of candidates who will be entitled to participate. The competition was increased, just like in the present case it is sought to be suggested that competition has increased.
All right, fine.
Yes.
We'll consider para 29 and 32 as you have stated.
Yes.
Yes.
Similarly.
And my lords, similarly, my lords will find in the other judgments.
Para 29.
There in the note. So relaxation, it is only the increase.
My lords, in that particular paragraph, the court has held that consequently, may I read that part, my lords? In paragraph 29. Particularly, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There can be no relaxation in terms and conditions of the advertisement unless such power is reserved. And in this case, the advertisement reserves the power. I will show that particular provision where advertisement has reserved it. Now, unless such power is reserved, such power could be reserved at a relevant statutory.
All right, we'll consider.
My lords, can I show the reservation of the power in the advertisement
We'll consider,
itself?
ma'am. We'll consider.
My lords,
Come
that
to next.
my lords, can I show the
Come to next point, ma'am.
192.
my lords, may just take page 192 for a minute, please. My lords, page 192, bottom of that advertisement. And the whole advertisement has been subsequently modified at least on 8 occasions, my lords, before even the...
Said, ma'am, you have said. Please, go first.
My lords, bottom of the page.
Yes.
Commission reserves the right to change the schedule and the format of the examination due to unavoidable reasons.
All right. Consider.
Then the doctor's list.
Come to next judgment.
Then, my lords, the point on... my lords, these 3 judgments are only on this particular aspect that an advertisement can be modified. There have been revisions to an advertisement and the court has upheld that. Now, my lords, there is an argument on the legitimate expectation that has been made on the other side. I would submit this that
I have on the constitutional bench judgment.
my lords, that is that CT Shivakumar judgment that my lords are referring to. And I just want to point this out, that in a line of judgments, CT Shivakumar as well as pre and post in the matters of judges appointment cases and all, my lords have taken this particular view that once an exam is held, the process has commenced thereafter. And if then a change has been made, it will amount to aspect of legitimate expectation. Here we are at a stage of advertisement, and advertisement
That
to
would
which
not attack.
that will not be attracted. That is my submission, my lords.
Cannot speak.
Yeah. Now, my lords, the other aspect that I wish to... My lords, the issues which will then arise for my lords' consideration, please take that first paragraph on page 1 and I'll close with that.
First paragraph.
Yeah, the very first paragraph, I framed the issues and I put them in the answer form. My lords, the petitioners did not implead any of the 4 writ petitioners which were pending before the High Court. They have not impleaded any one of them. Now,
These people, they come first time.
so petitioners raise any grounds? My lords, the ground that has been raised today about the aspect that their rights are being affected or that this is a change of the game once a game has begun is nowhere there in the SLP.
But then,
My lords, it's not there. It's not there. They have not taken the ground. And my lords, therefore, the pleadings get constrained to that extent. Pleadings can only deal with what has been urged. If a counter has to be filed, it will deal with what they have presented.
Madam, what you are saying, did the petitioners raise any grounds as raised before this honorable court? before the High Court.
No.
So they were not a party in the High Court. It's no question of raising of that.
My lords, but at least the ground.
Come to next question.
My lords, but at least the ground. Now, this is very important. There is no challenge to the notification of 29 January 2024.
That you have said.
That I have said.
We'll consider this.
Yes, my lords. Now, my lords, the point is,
when did advertisement dated so and so rules
attain their finality? My lords, that I respectfully submit, they attain finality after when they challenge this particular advertisement and they challenge the rules of 2022 before the High Court. The High Court rejected that challenge and they filed an SLP. That SLP has been dismissed on 9/9/2024. So therefore, those particular...
Just clarify.
Yes.
Whether this rule of 29 January 24.
Yes.
Or
that has not been challenged. That was not a part of that. I'll answer that.
The advertisement was changed.
Today also it is not. Today also it is not a subject matter of challenge. That particular rule.
Okay. So that is not under challenge.
My lords, that
22 rules was under challenge, as you stated yesterday.
Yes,
I'm rightly remembering if. So that was against that petition was dismissed.
Yes.
And SLP filed that too was dismissed.
My lords, only one thing that I may add here for my lords' consideration. Advertisement number 13 was also a subject matter of challenge. On one hand, you rely upon that advertisement today to say that after the advertisement is issued, you can't change. There you have challenge. That is it.
We are 11. Go next.
Now, my lords, whether the petitioners have to they disclose that they had challenged the same. My lords, I leave that. That's a part of my first part. I will not deal with that. Now, my lords,
the petitioners have pleaded in SLP that they are challenging the amendments from.
They have not pleaded. They filed an application. They filed an application, nothing more. So that is not under challenge.
So the fulfillment of eligibility qualification.
They are. Because this has been a subject.
This question.
My lords, the fact.
Petitioners were aware
yes.
of the fact that fulfillment of eligibility of the qualification as on the last accepting application will be taken into consideration.
Yeah. But there should be last date of accepting the applications. My lords, this what I mean to say. My lords, my learned friend corrects me on the aspect of the rules of 2024 amendment 29. He says that when the rules were challenged of 2022, they were challenged with the prayer of all amendments to date. And now when
those were challenged,
my lords,
prior to the amendment or before the amendment?
My lords, they were challenged prior to amendment to date. But the SLP was filed in the Supreme Court against that. And therefore, always an SLP will be an extension of that, and all those amendments have to be considered. Yeah, my lords, they may not. But what I'm saying is, amendment to date is their verdict. Yeah.
Consider your argument.
Yeah, my lords, I leave it there. But the last point that I was trying to make is that they had full knowledge that people had filed writ petitions, and the fact that there had been changes in the eligibility conditions consistently. Even after the advertisement, including in January, and the exams were finally held on in April, May and June. And the last date was 8th of April 2024. So they were completely cognizant. They had full knowledge about that. So this cannot be said that the rules of the game have